evening and welcome to the Womxn Show. I'm Lanina Rasool. Tonight we're coming to you from our comfortable couch to discuss uncomfortable topics, and the topic for this evening is the granting of bail in sexual offences and violent crimes against women and children. Now, bail has been a contentious issue for the longest time. In 2018, it was one of the demands handed to the president when thousands of women marched to parliament across the country. And in 2019, it was mentioned by our president when he called for harsher restrictions around the granting of bail in violent crimes. Tonight, we're going to be looking at what is bail, what are the legalities around granting bail, and what is the role of the victim and the communities in this process. But before that, a few episodes ago, we interviewed Lynn Hill, who is the survivor of gender-based violence and the author of the book, Butterfly, My Soul Got Wings, What Life Has Taught Me. She spoke about waking up from a coma and finding out that the perpetrator is out on bail. Let's find out what that experience was like for her.
So you were in hospital for under sedation for
I was under sedation for 72 hours.
And when you came out, he had been released on bail.
Yeah.
And bail, I think especially in South Africa and especially over the past year, but over the last few months has come up again, is a bone of contention for many communities and activists and especially survivors of sexual assault. Can you speak a little bit about what that felt like to you and what kind of message that sent to you as a victim of trauma?
I think that was really the first betrayal, judicial betrayal. There was a spate of it, but that was really the first one. It was how possibly does someone who nearly killed me and who killed might not have gotten it right physically, but had killed so many aspects of my innocent self without anyone's permission, without my permission. How does someone like that get to have his human rights protected when he violated every single one of my rights, when he fed off as a male, he fed off my vulnerability as a defenseless 15-year-old female who had never, ever been touched by a male. At that point in time, I had only experienced one kiss. What was the question again?
You actually answered it.
So the bail thing.
How that felt and what message that sent to you as a victim.
I think it was that my suffering had not been enough, that my suffering had not been, that I was not sufficiently violated, that something, and that this individual was protected by a system that I, as a victim, eventually had to fight, and that didn't seem fair. So this happened on the 1st of January. I was given the first court date for Regional Court Wynberg was around the 17th of July. So for 7 months, I lived in absolute trepidation, afraid that I would bump into him, afraid that he would come after my life, that he would be raping me again, or have someone kill me so that I would not provide the evidence. So it was months of fear, and it was really balancing this fear and trying to be as normal a student, because I was in grade 10 that year. So I still needed to be a student, and I still needed, and I wanted to be a child to my parents, and I wanted to be brave. And I knew that I could not lose my sanity. But I did on one Friday afternoon when I saw him in Wynberg Main Road. And I lost it. I screamed and I ran. And a traffic cop who knew me actually came to my aid and actually then dropped me at home.
Welcome back. You're watching The Womxn Show. I'm Lenina Rasool, and tonight we are speaking about the granting of bail in sexual offences and violent crimes against women and children. Now, in 1995, Alix Carmichele was attacked violently by a man who was out on bail despite the charges being rape and murder. She then went on to sue the state for damages. This then turned into a 15-year-long trial in which the state was eventually found liable for those damages. We're going to speak to Alix Carmichele about why she sued the state and about what that experience was like for her. Hi, Alix. Thank you so much for joining us. So, Alix, you were attacked by a man who was out on bail, and then you sued the state for damages. For context, can you run through what made you believe that the state should be liable for the damages that you suffered?
I had absolutely no idea that my assailant, Francois Couture, had a 4-year suspended sentence for aggravated assault. But I did find out subsequently after he'd attacked the second woman, Jameelah Blanche. And that's when I started going to the public prosecutor here in Knysna and saying, please, you have to do something about him. He's a danger. He was staying at Mitzi. He admitted that he couldn't control himself around women in bathing suits. I mean, they had all this information that said that their hands were tied and couldn't do anything. So leading up to my assault, I met an advocate in Port Elizabeth, and he said that there was a circular that had been released to all the provincial magistrates saying that their hands weren't tied, but they could make a decision about criminals who had a previous violent history. And he said, if there's anything, go back to the public prosecutor and explain that to her. And because they let him out on his own recognizance. I mean, he nearly murdered a woman and then was let out on free bail. So they didn't take his 4-year suspended sentence into, they just didn't take it seriously, obviously. And then they did nothing. And then what happened there, then 2 weeks later after meeting this advocate in Port Elizabeth, I was attacked by him. And he was phoned immediately and told the news, and he said that I must take action against the state because they were culpable for this. So that's why I did it. I mean, I didn't, recover from my injuries and go, right, and I'm going to sue the state. And there was no talk about money at that stage. Not that that was the issue. The issue was that I had to prove that they had a duty of care towards ordinary people like me.
Thank you. So, Alix, the case went on for many years. Obviously, this must have taken a toll on your emotional health, on your financial health, and just on your life in general. Could you tell us a bit about how much of a disruption it was to your normal way of life, given that you were already recovering from a violent assault?
Well, Jameelah, the whole thing took 15 years. So the first part of the case was it was a test case, obviously, so I had to prove that they did have a duty of care towards, women and children. Bouncing in and out of every court in South Africa for 7 years, it did take a toll on me. But that was just the merits of the case because the case was split. So then it took another 7 years to determine the quantum or the damages. And that was a completely separate thing. But to answer you about the first 7 years, I think, I was so deep in it. And at first, obviously you take something like that really personally, that you've been assaulted and, it's an outrage. And meantime, the statistics over a weekend of the amount of assaulted women in this country is an outrageous amount. So at first it was personal, and then as the case proceeded, sort of gearing, going in the direction of the Constitutional Court, I realized that it wasn't about me anymore. So that's what actually kept me going. I mean, each time it was thrown out of court or dismissed, we appealed, and it just gave me, it just made me more angry, I think, and that's what drove me to that point, to actually getting to the Constitutional Court.
So, Alex, had you ever thought of giving up or been advised to give up? And if yes, what made you keep going?
Well, after we won, you've got to realize that I had a very ego-driven legal team. So this was a test case, and they were all going to get some kind of recognition out of it. And then by the time, we won in the Constitutional Court, the only person who advised me not to go forward with the quantum was one of my advocates, because he said, well, you're going to go into the law books now, and it's going to be a test case, and people are going to use it, and it's going to save lots of lives, and I think the analogy that he used was that the state is going to throw me like a hectic curveball with the quantum, and if I don't catch that, I'm going to be liable for all the damages in the quantum case. So you must also remember that my whole court case was split, so merit and quantum. So that was another challenge for me. It's not that I wanted to be paid out money. What I'm saying is that money wasn't that important to me. It was the principle behind it. And they made me a really cynical offer, and that just pissed me off. So I didn't take the advice, and I went forward.
The case was a process where many levels of the institution, which is government, told you that you were wrong in the assumption that the police or the state was responsible for the damages. What kept you going in the face of all these rejections?
Well, yeah, you have absolutely no idea what I had to go through. I mean, I said to you when we first spoke that I would rather be assaulted by that man on the day every year than go through what I went through with them in the quantum. They picked at me and prodded at me and sent me to all kinds of experts. I also had my own experts. We had to have the same amount of experts to determine whether I was lying about my pain, the fact that I hadn't been able to work or drive, or how many operations I had. I mean, it just became absolutely ridiculous. They even suggested that I had overseas bank accounts, and I didn't need to do this. I didn't need to do that. And I was lying about what I was doing. So they had a whole bunch of experts, from psychologists all the way through to orthopedic surgeons, neuroscientists, neurosurgeons, trying to disprove, in a kind of what they called an unbiased way, which is absolute rubbish, because they were being paid by the state to present a report that was favorable for the state and against me. So, it was completely biased and very, very cynical. And that nearly killed me. So when that was over, my legal team then, which was a quantum legal team that had nothing to do with the first lot of lawyers, wanted me to appeal the judgment, and I just said no, because I'd had enough. I was exhausted. It took 15 years of my life to change a law in this country where they teach it to law students. So it's valid, and I don't know why people aren't using it. Years ago, a TV journalist friend of mine, I was moaning to her, saying, "What did I do this for? Why did I waste my life? I could have been doing other stuff. I could have had a proper life." what was the point of it all? And she said to me, she said, nothing's going to happen now, but you'll see in 20 odd years, somebody will pick this up and run with it. So what you've done isn't in absolute vain.
Alix, thank you so much for sharing your story with us. There's a lot of women out there who are going through the system for various reasons and coming up against barriers. As someone who spent 15 years taking on the state, could you offer some advice to women who are out there?
Well, I was thinking about that question because when you say like system or justice system, it implies that it's a well-oiled working machine, but it isn't. And I also think that the men who are a part of that system, like the judges and the lawyers, they don't really care about what happens to women. I mean, just the case in point, when I went to the appellate division in Bloemfontein, one of those judges actually said about Urena Blanche, she was assaulted before me. He beat her up so badly and raped her. She was lying in her own blood in the mud, and he got a fright. He actually went and handed himself over to the police. That esteemed judge, on a scale of 1 to 10, gave that a 5 in the appeal court. I mean, obviously he was wrapped over the knuckles for it, but that's the initial reaction. It's not a bad thing. It's a normal thing, I forgot actually the crux of the question. Well, how would what would I advise to women going through this? Petitioning the very people that, or protesting in the street against the very people that are in control of that kind of judiciary and this government, I don't think it works. I think there must be another way that women can band together and make a statement. There must be some kind of loophole where this government and the judiciary can be sued in a class action. That's what I think. I think to do it individually is absolutely pointless. They undermine you. You're just an hysterical woman. We don't really take you seriously. I mean, come on, you must know that. I'm like borderlining here on feminism, but we don't even get paid what men get paid. So how are you going to be taken seriously when you are accusing another man of brutally assaulting you and raping you? I mean, they don't take it seriously. And I say they, it's a huge generalization, I know, but that was my experience. I mean, I had a very ego-driven group of lawyers, and they wanted a name. They wanted a name associated with the test case that was going to go down in South African law history. So they didn't really, really care what I was going through or about what I was going through. If you want to do it, if you want to go into that system, you need the support of your family, and I'm not talking financially. You need the support of your friends, also emotional support, and you need somebody who knows the law and who's going to help you. And there are groups like that. But there's so many people, there's so many women that are being attacked and raped, and they can't cope with like a pro bono thing. Obviously, people have to earn a living, even in lawyers have to earn a living. But I just think that you have to find a way to find a loophole in that system. And that's why I say like a class action. I mean, if all the women who have ever been raped and assaulted in this country brought a class action against safety and security and justice, essentially the government, you might have a chance. But I mean, look what's happening now in this lockdown. The government is people are suing them and they're winning their cases, and it's like they're happy about that because they've got too much power now in this lockdown, and this is when these things are happening. I mean, I nearly puked in my mouth when Cyril Ramaphosa said the second biggest pandemic in South Africa is gender-based violence. I mean, do you honestly think he really is a toss about that? I don't think so. I mean, I thought, what is he even saying? He's got nothing to say about anything, and then he's saying that, that it's the biggest second pandemic. I mean, what about before the lockdown?
Exactly.
What about before? No.
Thank you, Alex. Thanks for coming on the show and sharing your thoughts with us. That was Alix Carmichele, who was brutally attacked in 1995 by a man who was out on bail despite charges of rape and murder. Now we're going to take a short break. When we come back, we'll speak to a lawyer and legal researcher about the legalities around the granting of bail. Welcome back. You're watching The Womxn Show, and tonight we're talking about the issue of bail in sexual offences and violent crimes against women and children. Joining us now is Jameelah Omar, who is a lawyer and a legal researcher and lecturer at the University of Cape Town. Jameelah, thank you for joining us.
Oh, you're welcome. Thank you for having me.
So Jameelah, different crimes fall under different schedules depending on how serious it is. For instance, gang rape falls under Schedule 6, rape would fall under Schedule 5, and I think bail is discouraged in more violent crimes, and yet we see it happening all the time. Can you give us an idea of how this works and what bail conditions are granted to which scheduled offences?
Sure. So the schedules in the Criminal Procedure Act are just there to categorize offences, so that other sections of the CPA the Criminal Procedure Act can simply just refer to a schedule instead of each individual section having to list a set of offences. So it's just an easy way for other parts of the Act to refer to a particular list of offences. So it's just for category purposes. And it's why you'll find sometimes an offence appearing on more than one schedule, because it might be in Schedule 1 in relation to bail, or it might be in Schedule 7 in relation to prosecutorial bail, for example, and it might appear on both in different ways. So the schedules are just, they can seem quite random, but it's for ease of reference and not for any other reason. And then in relation to the Schedule 5 and Schedule 6 offences, so it's not true that you can't get bail for Schedule 6 offences. In fact, there is no offence where there's a clear prohibition on bail. There's a right to appear before a court within 48 hours if you are arrested, and to have a hearing to determine whether you should remain detained pending a trial. So there's no such thing as you can't get bail for a particular type of offense. What happens for Schedule 5 and 6 offenses, because the offenses in those schedules are more serious, or to put another way, they include an element of violence, which is more particularly what the court would be concerned with. And so for Schedule 5 offenses, there's a higher threshold that the accused person has to meet. So normally the test is that the court will consider whether it is in the interests of justice to release the person, the accused person, on bail. For Schedule 5 offenses, the accused person has to show that it's in the interests of justice to release them. And for Schedule 6 offenses, it's an even higher threshold. The accused person has to show some evidence that exceptional circumstances exist that in the interests of justice they should be released on bail. So it is a higher threshold and so should be more difficult to get bail, but not impossible.
Thanks for that, Jameelah. So let me ask, someone is arrested, he is charged, and he applies for bail. What we've heard is that there are different types of bail. So we have police bail, we have bail that is granted at court. I think the prosecutor can also grant bail. Can you give us an idea of the stakeholders in this process and how bail is granted?
Sure. So generally, most people go through a court hearing and have what we colloquially call court bail. That's the kind of standard understanding of a bail hearing in court. But there are two other categories of bail. As you've said, police bail and prosecutorial bail. Now, how those two types of bail processes work is that they would normally take place within the first 48 hours. So if someone is arrested before they are taken to court after the 48 hours, they may get police bail or prosecutorial bail. Both of those, I think police bail, if I'm not mistaken, is for Schedule 7 offences, or maybe prosecutorial bail is. And generally, you'll find that the offences for which you can get police bail or prosecutorial bail are of a non-violent nature. So they're less serious offenses. What will happen then is if someone is arrested, for example, and are in the police holding cells, they might, if the type of offense that they are arrested for qualifies them for police bail, that might be granted by the senior police officer in consultation with the investigating officer. And if they are released on police bail, they are given a court date and time, and that would normally be 48 hours after that point, in which they need to appear at court. Once they appear at court, the court will hear the reason why police bail was given, and the court has the option to confirm that bail or to overturn it. So there's still, even if someone has gotten police bail or prosecutorial bail, the court still has to effectively ratify that decision.
So I'm going to backtrack a little bit here, Jameelah. There are also victims within these crimes to consider. Do the victims have any say or any influence in granting bail?
Sure. So the relevant bail sections in the Criminal Procedure Act are found around about Section 60. And Section 60 is quite clear about the factors that a court must take into account when deciding if bail should be granted or not. So there are about at least 5 clear factors that are listed, and they are firstly whether the accused is a flight risk. So and I think, let me just pause here in listing the factors to just discuss this issue of the flight risk, because I think that is one of the most misunderstood issues about bail. The reason why someone might be kept in custody pending their trial is because they might not be trusted to stand trial. The whole point of arrest is to ensure that the person shows up in court. It's not some kind of preemptive punishment. Because the person hasn't been found guilty yet. The accused person is accused. They are innocent until proven guilty in terms of our constitutional rights. So the primary reason why someone should be detained pending their trial is because there's a fear that if they are released, they will abscond. And so that's the primary thing that the court will look at. What is the likelihood that this person, if they are released, will actually come back in 6 months or whatever when their trial date is set down? So that's the one factor. The court can also look at whether there's any chance that the accused person will interfere with any witnesses, including the complainant. They can look at whether there's a risk to public safety. They can also consider whether there will be some kind of public outcry that will result in harm to any person, including the accused person. So there's quite a few things that the court can take into account. They can also take into account whether the accused would have the opportunity to interfere with evidence if they were released. So to give an example, say there was a murder charge and the murder weapon has not been found. The court might, and certainly the prosecution would argue that the accused person, if they were released, would know where the murder weapon is and have the opportunity to dispose of it before it could be found by the police. So those are the broad factors that a court can take into account.
And so, what sorts of bail restrictions are common or applicable when an accused is granted bail? And can victims request certain restrictions during this process?
So generally not, as far as I understand. Again, because this is a decision about whether the accused will abscond or whether the accused poses any particular risk either to evidence, witnesses, or general public outcry. Unfortunately, it's not really a factor, or a relevant factor is not how the victim might feel about their release. However, if a complainant has already been approached by the prosecutor who will be running with this matter, it is very possible that they can give information to the prosecutor about their sense of fear. Maybe some threats have been made already about what would happen if the complainant were to report the case, for example, that would be helpful to the prosecutor in putting that information before court. But generally, any arguments against bail would be made by the prosecutor and not directly by the victim.
So, Jameelah, we've seen lots of communities protesting at bail hearings, lots of calls for no bail. Do these protests play a role in the decision to grant bail at all? And also, what is a community's role in this as well?
Okay, so normally bail consists of a sum of money that the accused person has to pay, and that is kind of a security that they will attend their trial. And if they fail to attend their trial and they have no explanation for why, maybe they were hospitalized on that day or whatever, but if they don't have that kind of explanation, then they forfeit that money. So that amount of money is meant to be an incentive to get them to come to court. So sometimes you'll see a lot of outcry that someone accused of a very serious offense maybe only got 1,000 Rand bail, for example. And then the public sense is that 1,000 Rand is not proportional to the seriousness of the offense. But the amount of money is not meant to be proportional to the seriousness of the offense. It's meant to be proportional to what the accused can afford. It should be an amount of money that for the accused person would be not worth losing. So they wouldn't want to lose 1,000 Rand because they can barely scrape together 1,000 Rand, for example. So that's one of the other misunderstood things about the amount of bail money. In addition, the court, so almost always the court orders a sum of money. But in addition to that, the court can also order certain bail conditions. For example, like in the case that you're talking about, that the person is released on bail, but they're under house arrest. So they can't go anywhere, they can't interact with a broader community. It could also be conditions like the accused has to check in at a police station once a week. It could be electronic monitoring, but we don't have the resources for that to be rolled out more broadly. It could be a restriction on where the accused can go. So it could be, for example, in the case that you're referring to, that the accused can't come into contact with any minors, but it could also be a geographic restriction. So the accused is not permitted to go into a particular area, perhaps the one where the complainant lives, for example. So the court can be quite creative in the types of conditions that it orders. And in my view, the conditions for bail are there's the capacity for that to be the most important way of ensuring safety when someone is released on bail. And I think that courts need to use the possibility of conditions much more than they currently do, instead of putting too much emphasis on the amount of money.
Thanks, Jameelah. So just to conclude, in terms of advocacy, what are better ways that communities and also victims and their families and support structures can contribute to this? And if you're saying that, we've heard bail is a constitutional right, how can we advocate and lobby better for greater restrictions around this?
Yeah, so I think one thing is to be aware of the types of conditions that can be put in place, and if there's contact with the prosecutor in a particular case, it's to argue very strongly for the prosecutor to put to the court that there should be some stringent conditions put in place. The problem with bail hearings is that not the problem, but the practical obstacle to the community advocating for conditions in a particular case is that the bail hearing happens very quickly. So like I said, it could be as early as 48 hours after arrest. A lot of the time the bail hearing is postponed for 7 days, so that there's enough time for both the prosecution and the accused to prepare properly for their arguments. But that's still a very short time within which the bail hearing has to take place. In that time, it's often very difficult for the prosecutor to make contact with the complainant or their family to get any kind of representation from them. Our prosecutors are heavily under-resourced and are running hundreds of matters at the same time. So I think if possible, that is where the complainant could play a more active role, is going to the court and finding out who is the prosecutor that has that matter, and then asking for a meeting with them, but knowing that they can't play an active role in the bail hearing. All they can do is put the information they have to the prosecutor and ask them to put that to the court on their behalf. I think bail is one of the so I find myself quite conflicted about the calls for cancelling bail for serious offences, including sexual offences. Although I'm a very strong anti-violence against women and children advocate, as a lawyer, I understand that legal rules have to be applied consistently, and it would fly in the face of fairness and our constitutional rights to say that generally accused persons can be released on bail, except for these categories, because I think that could become a slippery slope where more and more people are denied their constitutional rights. And the reason why, part of the reason why I say that is because I don't think that harsher bail laws are going to do anything to change the extent of violence against women in this country. I don't think that saying to accused persons you can't get bail is going to reduce the number of cases or significantly deter people, men in particular, from perpetrating sexual offenses. So to me, that is not, I don't think it's realistic. I don't think it complies with our constitutional democracy. And most importantly, I don't think it's going to work. So I would advocate rather for communities putting their time and energy into education campaigns, into campaigns against violence. And I would urge the state, instead of rewriting bail laws and parole laws, all of which are hard fought for rights post-apartheid, is that we rather focus on socioeconomic and other social issues that would then have a knock-on effect into reducing violence in our society generally. It's a much longer project than simply just saying, let's take away bail. But I think that is the real project.
Thank you, Jameelah. I completely agree with you. I mean, we need to obviously tackle this issue at the source, and the sources in our communities and our homes, and looking at, positive behavior change, obviously, so that we reduce violence against women and children. I just wanted to throw in, though, if you have any thoughts on the Carmichele case, where what was interesting is that she went up to the Constitutional Court, and there they found that there was a duty to protect, that the police have a duty to prevent violent crime from happening. And so when I read that, I thought that might also be very interesting in terms of society, in terms of the accused. We've sort of broadly mentioned it already. But in relation to the case, if you have any comments or if there's anything in particular that you think we should know.
Sure. So, I mean, Carmichele is one of the landmark cases, as we refer to it, one of the most important cases that developed the law. But it's important to know that it developed the law in the law of delict, or torts, as some people might know it as, not the law of criminal law per se. So what it did was, it was a case about whether the complainant could claim damages effectively from the state for failing to protect her, because the accused person was someone who had been released on bail, but had a history of sexual violence, and was accused of perpetrating 2 other sexual offenses against 2 other victims. And what the Constitutional Court eventually said was that this was a situation where neither the police nor the prosecution had argued in court for bail to be denied. They had agreed that bail, well, effectively they had agreed by silence that bail should be granted. In fact, the police had presented a report that that didn't disagree with bail being granted, and the prosecution didn't put before the court information about the history of violence that the accused person had. And so the court made a decision to grant bail without a full picture of everything that they should have taken into account. And that was the failure. That was the failure to protect that the court ordered was lacking on the part of the police and the prosecution. So it wasn't a general duty to protect. It was a specific duty in relation to a bail hearing and what the duty of both the police and the prosecution is, to give the court the relevant information that it needs.
Okay, thank you. Thank you very much. That is great. And that also speaks to your previous comment, encouraging, I think, not just complainants, but sort of society who know, I think, certain facts or have certain evidence about an accused and past, to just ensure that that is brought before the court, before the bail hearing, or at least presented to the prosecutor.
Yeah.
So
I mean, if I could just add, so that it doesn't sound like I'm advocating for, kind of public advertisement of an accused past, but it's but it's for complainants or anyone with such knowledge to give that information directly to the prosecutor. It would end up doing more harm than good if that kind of information was widely put out on social media or any other forum, because then it's more likely that the accused person can argue that they are not going to have a fair trial. And the most important thing is to ensure that if a complainant has been courageous enough to come forward and lay a police complaint, that the trial will go ahead and that there will be justice at the end of it. And so things like putting information into the public domain is probably going to be detrimental to that rather than helpful.
Thank you so much, Jameelah. Those insights were fantastic and really helped us understand the issue better. That was Jameelah Omar, who is a lawyer and a legal researcher and lecturer at the University of Cape Town. We're going to take a short break, but we'll be back with more after this. And that brings us to the end of the show. Remember, you have a role to play in this process. If someone is up for bail and you're aware of anything that should be considered during his bail hearing, reach out to the prosecutor and share it with them. I'm Lenina Rasool. Thank you for joining us. Good night.